Hello, my name is Jesus Jaramillo. This presentation is for CYB 220, Topic 6, Assignment Injury and Fact. So, what is injury and fact? Injury and fact is a process that must be followed by a plaintiff who has been a victim of, in this case, a cybersecurity breach, so data loss or sharing of personal financial information, stuff like that. So, So the process is the plaintiff must go through to prove that their allegations of injury being that they were victims of a breach, are concrete, and that a violation uh, has been done by the company that was breached. So not necessarily the hackers, but the company. The company didn't do their due diligence to avoid the breach or the hack, and that must relate to Article 3 portion of the U.S. Constitution. So, what are the requirements for injury in fact? Plaintiffs must show proof that they were affected by the data breach. And of course, that would be a proof of injury. This can be done by providing the effects of the leaked information. This is a process of showing injury or harm caused by the breach. Examples of proof are identity theft. Usually that's documented by law enforcement or any company that's working with the victim. Financial loss. Obviously, if financial information was hacked, victims will lose funds from their bank account. Credit cards, debit cards can be used to purchase items that weren't purchased by the victim, but instead the hackers or anybody who bought that information from the hackers. You can also show personal devices if uh, credentials were leaked. Uh, uh, the hackers might use that information to reach apps on the phone or any computer, anything that was used by the victim legitimately, any app services. Of course, any other accounts for any other companies that maybe they were shared or somehow linked with the company that was hacked. And usually bank statements can prove financial loss. The victim can prove that there was purchases or activity that was not done by them, but actually done after the hack or the breach. Uh, Another thing that has to be done is did the injury in fact cause harm? Sometimes breaches happen and your information is taken, but nothing happens after that usually. Um, Depending on what information was stolen, hackers can't really do much with it. So the best thing to do there is to just be vigilant, keep an eye on your stuff, change passwords, anything that's recommended by the company that was breached or the lawyers or any third party that's representing that company. So in cases like that, there's really not much that can be done. But if your financial, personal, login credentials, that's the sensitive stuff with stolen social security numbers, then you can prove harm and hold the company that was breached responsible for not having security measures in place. Injury in fact concerning data breaches. So that's the main topic here of this assignment. It pertains to data breaches. So here's some information regarding that. Data breach cases are particularly good candidates for Article 3 standing arguments because data breach plaintiffs often allege a risk of future injury, uh, but but do not allege that the breach has caused them any immediate harm. So, okay, your information's out there. It was taken, it was stolen. It may sit in the dark web for a while until somebody purchases it or gets a hold of it, and then starts putting it to use. So, uh, doing your due diligence now and going after the company can help protect you in the future. It may not do anything now because nothing's been, you know, no harm has been done, but that doesn't mean that a year, 2 years from now, or a few months from now, there will be harm. So it's good to take care of that now before it happens, and then you have to kind of hurry up and try to get the process done quickly because there is harm now. So what can companies who are breached do? Companies can help avoid network breaches by strengthening core infrastructure as it relates to cybersecurity. Obviously, any modern day company out there has a network that involves resources used by employees. So these resources are hosted on servers, databases, and if any company does business with consumers, that information is going to be stored on a server or on a database. So those companies need to have security measures in place to protect that data. Companies can also train their employees to be more vigilant when it comes to potential bad actors. Most of the hacks start with a phone call. Um, a hacker posing to be a vendor, posing to be anybody who needs assistance, and the other end of that phone call is the employee who works for the company. And many times that employee is the weakest link in the armor, as they say. Enforce a better password policy. Credentials by employee credentials can be hacked, can be placed in the dark web. It's good to have strong passwords, passwords that expire 60 days instead of the 90 days, stuff like that. Better secure servers and databases to avoid leaking customer data, firewalls, anything, antivirus, anti-malware, anti-ransomware, dual-factor authentication, anything that can help secure servers and databases. Post-breach, companies should notify the public when a breach has occurred. Um, Many ways to do that: local news, internet, social media. Companies should put that information out there to get ahead um, and notify as many people as possible. Companies should also directly notify customers whose data has been hacked. So not everybody's data will be hacked, but the people who have a right to know. So the company should email them, call them, text message them directly. All that information is most likely stored within the company. This will allow for those affected to take necessary steps to lessen the impact of the hack. Obviously, the hack has occurred at this point. Doesn't mean that uh, customers and victims uh, can't take steps to minimize the impact. They can close bank accounts, close credit cards, change passwords, close accounts, uh, stuff like that to help lessen the impact. Summary. Article 3 of the U.S. Constitution can be used to help a victim prove injury in fact. This is important uh, because when a company is breached, there should be protection for the victim's rights. In this case, the victim is not the company that was breached, but the customers whose data was exposed. So we often think about the company that was breached as a victim. Well, not necessarily. It's the people whose information was hacked. They're the ones who are gonna have to deal with financial loss, um, identity theft, stuff like that. The usual targets and data breaches are large companies who should have had securities in place to help prevent the hack. The larger the company, the more money they stand to lose, and ransomware, uh, more customers they have, so more potential data that can be accessed. Now, obviously, there is no method that can block a breach at a rate of 100%. Nothing exists like that, but the company should do everything it can. Firewalls, better training, security, cybersecurity vendors, cybersecurity teams, uh, hardening of servers, databases, stuff like that. Cybersecurity insurance, uh, things like that that can help. Uh, there should also be a post-breach plan to help victims. Companies can now be held liable if they do not do everything possible to prevent the breach. And it's also important, like I said, to notify customers so they can do things on their end to help uh, limit the impact. Typically, liability is imposed if the following conditions exist. An entity failed to implement safeguards required by statute or reasonable security measures, failed to remedy or mitigate the damage once the breach occurred, failure to timely notify the affected individuals under a state's data breach notification statute may give rise to liability for civil penalties imposed by a state attorney or general. And that is cited quote, so I will provide that here. I do have it here, so I will provide the end quote, the in-text citation. And that is it. Back on the first slide, I will uh, include a link to this presentation. Thank you.